understands that a lawyer may be
Formed,
appointed if the
I never
defendant
said I
is
understand.
indigent and understands the disadvantages of
Never once said
self-representation.
I understand.
He is voluntarily and freely waiving the
As a
right
matter
to
of
be
fact, I do not
represented by
understand.
counsel and is making a deliberate choice to proceed without counsel. And therefore, the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keyes. And from this point forward, Mr. Brooks will proceed as his own attorney.
All right, while our live trials take their respective lunch breaks, we turn our attention to that trial, the upcoming trial of Wisconsin versus Darrell Brooks Jr. Jury selection began today for the 39-year-old who faces 6 consecutive life sentences. And as you just saw there, Judge Jennifer Doro granted his request to represent himself at a hearing last week. But that decision may have backfired after Brooks had to be ordered out of the courtroom a total of 4 times today. Brooks stands for trial for intentionally crashing his car into a group of people at the Waukesha Parade last November, killing 6 and injuring 60 others. Before I bring in my legal panel to discuss this trial, let's go back to the hearing last week where Brooks expressed his thoughts on victims in the courtroom.
Your Honor, I think fundamentally, it would be impossible for all these witnesses that want to attend to have not heard different stories from different people who were at different places in the parade. I think by now it's somewhat removed from the incident, but the media coverage alone, the reports that have been in the press, some of the witnesses aren't even in campaign ads for elections that are coming up. I think it's pretty logical that a lot of these victims have heard a lot of, if probably not the majority of everybody's story. I do agree with the fact that you make that very clear that it is public. They certainly should have a right to be here. And you also made it clear that there's a live stream available as well. You also made it clear that everybody is not going to be able to fit in the courtroom, no matter how much they want to attend the trial or not. The live stream is available for them. I just think I wouldn't go as far as to say it will be confusing to the jury, but it would be issues, I believe. What if some of these witnesses are some of the witnesses that gave statements and something that comes up in somebody else's testimony might not spark something in them and say, oh, I forgot to say that. And then now that becomes a discussion, which I don't think anybody would not have had a discussion amongst themselves about what they have heard to this point and what they will hear. I'm quite sure it'll be a lot of breaks during the trial. I think it would virtually be impossible for somebody not to have a statement or to make a statement or for somebody to overhear something that may want to be brought to the attention of the state or victim advocate or something like that that may find its way into testimony that probably wouldn't have been there from the beginning. So I think I would agree with when they were my attorneys with what they filed.
Well, if you thought that back and forth between the judge and defendant looked hectic, that was nothing compared to this morning when there were quite a few hiccups at the start of jury selection. 7 minutes in, Brooks was ordered back to his jail cell for not cooperating and refusing to acknowledge that Darrell Brooks was his name. Judge Doro ordered another break after the defendant requested certified copies of her oath, and then a third break late morning. Then finally, just after noon, Brooks was removed from court. So to watch the proceedings in a separate room where he cannot interrupt. Now that we've gotten all that straightened out, let me bring in my legal panel to break this all down. Question is, does Judge Darrell have enough against Brooks to take his right to represent himself away? And if so, why hasn't she done it yet? Marie.
I think after his spectacle in the court, they should consider having him re-examined. Because before reaching this point, they had him examined and someone deemed him able to understand the proceedings and the seriousness of the charges and capable of representing himself, even though it's not advised. But now, after the fact that he can't even sit still and listen to the judge, I think they should revisit that and maybe have him re-evaluated for his competency to be able to represent himself.
Well, that's the thing. It seems like a lot of hassle here, Jean. Why did she even grant it in the first place for this to happen?
Well, I think way back, it seems like 3 weeks, but last week when she made the decision that he could represent himself, she showed extreme patience in arriving at that conclusion. She concluded he made a knowing and voluntary decision to represent himself. But Marie, I don't disagree with Marie, but I think the horse has left the barn on doing a competency hearing. She should have done one last week, not after she's made this decision. But at the end of the day, a defendant has a right to represent himself. A defendant has a right to be present. But there's a legion of cases at the appellate level and at the Supreme Court, going back to Justice Cardozo, where at some point your misconduct and your obstreperous behavior give a judge wide discretion to remove you from the courtroom because you are disrupting the process and the integrity of the administration of justice. So I think she's at that point, and I think she is on sound legal footing to remove him from the courtroom.
Well, Marie, is Brooks just stalling the jury selection process, do you think, at this point?
He definitely is stalling. And I think just the fact that even when he was waiving his right to a trial, he crossed out all the words that said understanding of the process and put informed should have been a red flag for the judge. And if I were the judge, based on that alone, I would have used that to say, do you understand? You must understand in order for me to even evaluate your ability to do this for yourself. And he keeps saying, I don't understand. And he even crossed out the word, I don't understand. Understanding is different from being informed. Understanding involves risk management, just knowing exactly what the process entails. And the fact that he refuses to acknowledge understanding should have been a red flag from day one.
Well, this certainly is going to be a circus of a trial, and it has not even started yet. We are all sitting in our seats waiting for it to happen. All right, Law and Crime is going to come back with so much more trial coverage. Stay with us.